Hey everybody, thanks so much for joining us today. It's Andy Hanasek here from the National Provisioner. We're here to do another video Q&A on the wide variety of COVID-19 responses, situations, challenges out there. And today I have Travis Cook here with me to talk a little bit about some of the litigation around, or potential litigation maybe that could be down the pike, and how processors might be preparing for it. So Travis, thanks so much for joining me. First, let's talk a little bit about the topic that we're going to discuss here from a 40,000 foot view a little bit. Employees are being temperature tested. They're getting their temperatures taken. They're being tested for coronavirus. Are the employee groups, the unions, are they making waves about the time spent to take temperatures of every employee, to test all of these employees? What are you hearing out there in the industry, at least at the processor level, when it comes to the weird juxtaposition of having to do these extra steps?
Thanks, Andy. And it's a good question. We haven't heard any real complaints yet, and we haven't seen any litigation that I'm aware of. But again, and probably the reason for your question is this wage and hour area is kind of the low-hanging fruit in the processing industry. We have seen the issue addressed from the EEOC more in terms of discrimination lawsuits in the Americans with Disabilities Act. So everyone recalls, generally, the Americans with Disabilities Act prohibits you from doing a medical examination of your employees. And the EEOC issued guidance that said this is a business necessity. But the wage and hour stuff, I'm sure will be litigated, and we don't really know yet how it's gonna play out. And there's a couple recent cases that are helpful, and I'm sure people will try to argue that this fits within. In 2014, Amazon won a case at the Supreme Court regarding standing in line to go through security, and the justices ruled that was not part of their duty. It wasn't work. I mean, obviously the employers will argue that this is the same as that, but the other side will take the position that it was part of their job and needed to be paid.
Travis, how do processors avoid a new wave of these wage and hour litigation potential cases out there? Considering these have plagued the industry for the last decade and a half, in terms of where these might come down from the temperature taking and the virus testing standpoint. How do they avoid it?
Thanks, Andy. And it's a good question, and we'll see who did a great job. I mean, my general advice to my clients has been get the fundamentals correct. So if you have salaried employees or non-exempt employees, as you're bringing them back and you're maybe altering their pay, be careful about how you do that and understand those basics. Same as tracking leave. Specific to what's happening here, it's not only the temperature checks, but it's also the PPE that's being required. So in those cases, it'll look at your policy and evaluate how you're paying and whether or not adjustments need to be made. For instance, if you're running gang time and then adding plug or K code time, they may need to be adjusted depending on what PPE is required. Not only today, but if additional PPE is required moving forward, that may become compensable under the act, or maybe arguably compensable. And I would say it's a case-by-case issue, and my advice, of course, is to contact your lawyers and look at the specific facts for the specific facility and come up with a strategy that you could defend, in the next 2 or 3 years.
Is there anything else, based on the history of these types of cases that you kind of went into a little bit in the beginning, is there anything else processors could be doing to defend themselves, just to make sure that if they are brought up in litigation, they have a good shot at winning, as opposed to the unions or the employees winning? How can they better defend themselves if there's anything beyond what you just mentioned?
Sure. I mean, again, I would reiterate that it starts with preparation, and it starts with contacting your lawyers early and getting them involved, and having that relationship so you can tailor a response to your facility or your company or your employees or your bargaining unit, however it may play out. I mean, some other things we've seen in the most recent case, there was a evidentiary issue that one side had an estimate and the other side didn't, and that became an issue, which is challenging based on other parts of labor law and whether or not you can record this or not. I mean, generally, those are case-by-case issues that need to be addressed with your lawyers and your local or your management. Generally, the rules are prepare your team to deal with these issues, and then come up with a plan that you obviously think fits the law and you could defend.
Great, Travis. Yeah, it makes sense. Obviously, every case is different, and every processor, every team, every lawyer is different. So I appreciate you giving the advice you can, and for you bringing this up to our processors, our viewers. Thanks so much. We'll do another video here in a little bit, and on a different topic. And I appreciate you joining me today.
Thank you, Andy.